New at 5, a White Lake homeowner has been charged with manslaughter in a shooting back in July that raised some questions.
The prosecutor says Dayton Knapton shot a 17-year-old who was trying to steal items from his garage.
Dayton Knapton is currently facing manslaughter charges in the state of Michigan when a group of teens, a group of youths, broke into his garage at 1 o'clock in the morning, and he responded to these youths by firing upon them while they were in this garage. Now, of course, this has caused a lot of debate across the internet.com on whether or not this should be covered by the Castle Doctrine or by regular Michigan self-defense law. But in this video, what we're going to do is actually examine the facts of the case as presented by the prosecution. We're going to hear a little bit from the defense attorney of the man who is being charged. And of course, we're going to examine the laws at issue to determine whether or not this man, Dayton Knapton, will likely be convicted of these manslaughter charges. We are also going to talk about whether or not the teens, the youths, who are facing charges in relation to the burglary that they were committing at the time that one of them was shot and killed, should face additional charges for the death that resulted from the felony that they were committing. But before we get into that, I will remind you guys that Nate the lawyer, friend of the channel, is expected to undergo brain surgery tomorrow to remove a rather large tumor from his brain, as he indicated in a video that he posted about a day ago. And I want you guys to go over to his channel, send him some love and support. And by the way, I'm making this video in Nate the lawyer style, where I disregard my personal opinion and just go based on the facts, the legalities, in order to present you the proper outcome. So I hope he appreciates this, because Nate, you are well loved on the internet.com, well respected by people like me, and I wish you a speedy recovery. But again, let us get into the facts of this case.
Yeah, and there's a lot of different sides we're hearing. We're hearing from the prosecutor's office, that man's defense attorney, and the family of that teen who was shot and killed, and they're upset.
It doesn't make sense. It doesn't make sense, and it hurts a lot.
4 months after 17-year-old Sivan Wilson of Pontiac shot and killed in White Lake Township, his family says the charges have them confused.
I think the way they went about it, it could have been done better.
24-year-old Dayton Knapton charged with manslaughter, assault with intent to do great bodily harm, and 2 counts of felony firearm for the death of Wilson and shooting another teen in the leg. Wilson's family says they want Knapton charged with murder.
It doesn't make sense that it wasn't done out of malice, and for them to charge him with manslaughter when everything in the report is suggesting that it was malicious intent.
So first and foremost, right off the top, because we are going based on the facts and evidence as presented in this case, Erica Erickson, good looking gal. I'm not saying anything. I'm just saying if I didn't make commentary on it, you preverts out there would be obsessing over her. But as to the substance of getting the family's opinion on this particular case, the thing that they're actually agitated about is the fact that the man in question, Dayton Knapton, is not facing murder charges. They believe that this was a premeditated action. It goes beyond the scale of manslaughter, which I find to be patently ridiculous and absurd. And in order to understand this situation, you need to get a few key factors. So let us go to the statement from the prosecution's office so you can understand why they decided to press charges, and then we will compare and contrast that to the relevant laws and see whether or not this actually fits the situation. So according to the Oakland County prosecutor Karen D. McDonald, Dayton Knapton, the 24-year-old resident of White Lake, Michigan, is guilty, which is why she's charging him, of manslaughter, assault with intent to do great bodily harm, and 2 counts of felony firearm for the death of Sivan Wilson, age 17, and the injury of another individual who was shot in the leg. Additionally, 21-year-old Matthew Greenidge and 4 juveniles were charged with breaking and entering for the attempted burglary of Knapton's detached garage that led to the shooting. So before we get into the specific facts of the case, there is something that is absolutely crucial in my humble opinion that was just stated right there that is going to change the math in terms of the Castle Doctrine stuff. So I think it's important for us to highlight what that is. And that is the fact that we have a detached garage situation. So in this particular case, the Castle Doctrine is not going to be viewed as a valid defense, because essentially the Castle Doctrine in the state of Michigan only applies if somebody somebody breaks in to your home while you are occupying said home, your business while you are in said business, or your vehicle while you are in said vehicle. So right off the top, based on those parameters, we can actually toss Michigan's castle doctrine as a form of defense because the detached garage is in fact detached. So in reality, you're not going to make the claim that this person basically forfeited their right to their life as soon as they broke into your property, according to the castle doctrine. Now, to be clear, my personal opinion is I don't have any mercy or sympathy for these particular criminals. This guy apparently was suffering from multiple different burglaries at his property. These might be the same offenders who have been repeat offending on said property, but what we're talking about, again, a la Nate the lawyer, friend of the channel, who are wishing a speedy recovery, is whether or not this is actually applicable in terms of a defense for this case, and the castle doctrine is just not based on the circumstance of it being a detached garage. Now let us read a little bit further. On July 8th at approximately 1 a.m., a group of suspects, also known as teens, also known as youths, including the shooting victim, reportedly broke into the defendant Knapton's garage. Knapton left his house with a 9mm semi-automatic handgun and allegedly fired 2 shots into the garage through a windowless locked door. As the burglary suspects were fleeing, Knapton allegedly fired 5 more shots. He is then alleged to have gone back inside his house, reloaded his weapon, and returned outside. Wilson fled the scene with other suspects and reportedly was not taken for medical care for approximately 30 minutes. Wilson died from a gunshot wound. Investigators concluded Wilson was struck by one of the bullets that Knapton fired through the locked door. So based on that telling of the events, we have 7 shots fired by the homeowner against these criminals who broke into his garage. 5 of those shots were fired as they were fleeing, which, by the way, are going to be shots that are not going to be justified, and this guy is going to be in a lot of trouble, especially if one of those shots were the one that shot and killed Wilson. However, the prosecution's office is not actually alleging that. What they're alleging is that one of the 2 shots fired from outside the garage into the garage, which was windowless at the time, was in fact one of the fatal shots that hit Wilson. Now, I will also take note of the fact that Wilson was not taken for medical care by the group of teens, by the group of youths that he was with for 30 minutes. And the reason I'm going to pin in that at this moment is because I want to talk about felony murder a little bit later, or negligent homicide, or any of the other charges that should be attached to the criminals in this situation. But first, we got to go through Dayton Knapton's case, because as we talked about before, the castle doctrine cannot be invoked here. We have to look at the situations on which you can use deadly force in self-defense in the state of Michigan, and one of the positive signs in Michigan's law is the fact that you do not have a duty to flee in that state. However, when you read the law, it gets a bit troubling for Knapton. So we go to section 780.972, which is the use of deadly force by an individual not engaged in a commission of a crime, and what those conditions are. Requirement 1, an individual who has not or is not engaged in the commission of a crime at the time he or she uses deadly force may use deadly force against another individual anywhere he or she has the legal right to be, with no duty to retreat if either of the following applies. Again, this is absolutely crucial. And we go to A. The individual honestly and reasonably believes that the use of deadly force is necessary to prevent imminent death of or imminent great bodily harm to himself or herself or another individual. So look, obviously it is inarguable that Dayton Knapton was at a place where he was legally permitted to be. He was on his own property at the time that he fired these shots into the detached garage. However, it is going to be an incredibly difficult struggle for him to make the argument that criminals in his detached garage that did not have access to his dwelling, which he was currently presently in, pose an imminent threat of death or serious bodily harm to himself or other individuals who may have been residing at the property. So we're going to have to say objectively that on count A, Dayton Knapton is not going to have a good defense. He's not going to be able to cling to this. But let us look at part B and determine whether or not that is successful. B, the individual honestly and reasonably believes that the use of deadly force is necessary to prevent the imminent sexual assault of himself or herself or another individual. Now look, again, I am not a fan of giving criminals who break into people's properties a free pass or anything of the sort. I don't want Michigan's law to be written this way, but the idea that this guy was in fear that he was in danger of imminent sexual assault or somebody else was going to be sexually assaulted unless he fired into that garage is just not true. It would be a lie for me to tell you otherwise. So the fact is, on this particular section, section 1A and B, the guy's not covered. But let us go to section 2, and maybe in this particular section, we have something to work with. 2. An individual who has not or is not engaged in the commission of a crime at the time he or she uses force other than deadly force may use force other than deadly force against another individual anywhere he or she has the legal right to be with no duty to retreat. If he or she honestly and reasonably believes that the use of that force is necessary to defend himself or herself or another individual from an imminent unlawful use of force by another individual. So obviously right there, that section is specifically referring to non-deadly force, which means that according to Michigan self-defense law, by the letter of the law, this is actually not covered, and we might expect Knapton to be convicted for this particular crime of shooting burglars in his garage, which actually is pretty unfortunate. Now, of course, if this were in the state of Florida, where you can actually use deadly force in order to prevent a felony from being convicted, and burglary is in fact a felony, then I would be reporting something different to you based on the law. However, based on these particular circumstances, and by the way, if you're in the state of Michigan or in any state of the union, you should familiarize yourself with your self-defense laws. Knapton should be found guilty by a jury of his peers of this particular crime. And when I say should, I mean according to the letter of the law. Again, regardless of how I feel about teens getting repeated free passes due to the fact that they're innocent Baba Angel Aladdins who are just trying to break into his garage in order to feed his starving family, or their starving family.
Back in July, prosecutors say Wilson, along with 6 others, broke into Knapton's detached garage. Knapton coming out with a 9mm. Prosecutors say firing 2 shots through a windowless locked garage door. Then, as the group ran away, prosecutors say Knapton shot at them 5 more times, ran back inside, reloaded his gun, and came back outside.
Now, the local news segment actually has images of the home in question where you can see the garage and how close it is to the actual home itself, even though it's detached, and maybe this possibly changes the math for a juror that's examining this particular case, but in reality, Michigan law does not appear to cover this. I also want to point out that, of course, in this particular case, you have members of the family talking about what a good boy their little robber actually is, Sivan Wilson, even though that is obviously not true based on what we're seeing, based on the facts of this case, that he was burglarizing this particular property with a group of teens. By the way, the teens range in age from actual teenagers all the way to age 21.
Sivan was running away and got shot. I never heard anything about him getting shot in the garage.
But prosecutors say Wilson hit and killed from a bullet fired through the locked door.
We had a really close connection. So it hurts a lot. I would have never expected this to happen to him. He has so many dreams and aspirations.
But yeah, as we've seen in many of these cases, we also have the father appearing to just lie about the circumstances of this case, saying that his little innocent Baba Angel son was actually shot as he was fleeing and he was just trying to get away. He realized the error of his ways, and in reality, he was on his way to church at the moment in time where this evil white racist man ended up shooting at him.
Meanwhile, I just got off the phone with Knapton's defense attorney. He says Knapton was startled, and this case is one of, quote, stone self-defense, and he believes Knapton should have never been charged.
Now, I said earlier on that I also wanted to examine Michigan's felony murder statute because I think that's absolutely crucial, and according to Michigan state law, felony murder carries the same harsh penalties as does first-degree murder, and in fact, the felony murder statute is actually in a subsection of the first-degree murder statute, so let us jump to that subsection to see whether or not these criminals should be charged in the death of Sivan Wilson, and actually charged significantly higher than Knapton in terms of this particular case. So this is Michigan Law 750.316, and we actually have to jump to Section B to talk about what is covered. Murder is committed in the perpetration of or the attempt to perpetrate arson, criminal sexual assault in the first, second, or third degree, child abuse in the first degree, a major controlled substance offense, robbery, carjacking, breaking and entering a dwelling, a home invasion of the first or second degree, larceny of any kind, extortion, kidnapping, vulnerable adult abuse in the first or second degree under section 145N, torture under section 85, aggravated stalking under section 411I, or unlawful imprisonment under section 39B. Now, of course, the sections that are worthy of highlighting are the breaking into a dwelling, a home invasion of the first and second degree, or a larceny of any kind. Now, if you guys are unfamiliar with the theory of felony murder, it is as follows. If somebody dies during the commission of a felony, and by the way, that death is a foreseeable consequence of said felony or foreseeable possible consequence of that said felony, then everybody in the group ends up going down for that homicide. And the classic example of this is that you and a bunch of buddies, maybe a bunch of teens, go into a bank to do a bank robbery. One person shoots the teller. Each and every person in that group, including the getaway driver, is going down for that felony murder. However, in many states, you also see circumstances where if one of the parties in that particular crime dies as a result of the crime, that homicide is also pinned on those particular parties. And again, you end up with a felony murder charge. Now, this mission and statute is not all that clear about whether or not this would qualify. However, in my opinion, it would likely be something that would be worth pursuing, because in reality, each and every one of these people knew they were committing a crime, knew they were committing a burglary. They all agreed and had the requisite intent for that. And a likely foreseeable consequence when you break into somebody's property is that somebody will die if the homeowner or the person who lives there wakes up and reacts to the mob of criminals that have broken in. So I will ask the county in Michigan in question, Oakland County, where are the felony murder charges? Because in my opinion, it is totally applicable right here. Now, you could also make a case for a criminally negligent homicide in this particular case, because remember, Sivan Wilson did not go for medical care until 30 minutes after this particular incident, because the perpetrators involved very likely did not care enough about him in order to take him to the hospital, and they did not want to get arrested. And in my opinion, especially when you have an adult within this group, that is something that should be charged incredibly seriously. But again, not a lot of talk about that. Everybody seems to be directing their ire at the homeowner. But of course, as we talked about, that is not completely unwarranted based on Michigan law. Now, of course, I want to know what you guys think about all this down in the comments below, but also I will remind you that please send your support to Nate the lawyer. He really appreciates it. He is one of the good guys on youtube.com, and I know he's talked about this on a stream with me before, but I will reiterate it because it was an honor for him to say it to me. But Nate actually said that my channel and my examination of documents is what inspired him in part to do his channel, realize that this could be a successful model. And I just want to say that that is an absolute honor for him to say publicly. I really genuinely appreciate it. And part of the reason I appreciate it is because Nate is a lawyer. He's somebody who is already successful in his life. He was already good at this. And by the way, his YouTube videos are among the best in the business. And in fact, if you look at the record of who has gotten more cases right and wrong, Nate has a better record than I do. He is great at this. He is somebody that we should all appreciate, all support, because it's not only somebody that will be missed by his family, obviously, by his friends, by people who have gotten to know him a lot better than I have over the years, but he's somebody in the YouTube ecosystem that will also be missed dramatically because he is the best at what he does. And yeah, I genuinely am hoping that he pulls through. And if you guys are religious, he's asked for prayers, send your prayers, whatever you got to do. But that's really where I want to leave it right now. Again, Nate, you're so well appreciated. Thank you for helping me behind the scenes in the way that you have. And I am really sorry I missed that dinner we had scheduled, but you promised that you're going to pull through so you can take me out to that dinner. So yeah, Nate, see you next time.